Hello, everyone. I hope everyone's is having a great day today. So, my name is Elrin Kwan. I'm one of the lawyers here at No Borders, and I do specialize in migration. Today's topic will gonna be more about partner visa. So, I'm gonna be discussing to you more about, the different kinds of partner visas, what documentations that we need to attach on some of the documents that we need to attach on the application, and the common mistakes that the applicants have been doing, as I have experienced throughout my career as a lawyer. So, and by the way, thank you for attending this webinar. I'm going to be entertaining questions later on after I finish all the slides in the end. All right. So, as I've said, my name is Elreen, and I'm one of the lawyers here at No Borders. And No Borders has been existing for more than 27 years, and we do commercial, employment, migration, and property law. So we do have offices all over Australia as well. Our main office is in Brisbane, and one here in Sydney who is practicing migration. So we have almost 14 lawyers or 15 lawyers who specialize different kinds of law. So, and as I've said, like I do specialize in migration, so this is my field, and yeah, let's just enjoy the webinar. So the key discussions that we're going to be doing today is that I'm gonna be explaining three kinds of partner visa, the documentations, and the common mistakes that the applicants have been doing in the past years, which makes the application more complicated and which causes the delay, and further informations that being requested by the department, and makes the process really stressful, especially to the couple. So the partner visa, we do need two people in order for us to apply for a partner visa. So I distinguish it firstly would be the sponsor, and the second one would be the applicant. So enable for the applicant to apply for a partner visa, we do need a sponsor. And the sponsor needs to be either an Australian citizen, a permanent resident, or eligible New Zealand citizen. So in my career, I haven't experienced like a sponsor as eligible New Zealand citizen. I do most of the time I always encounter like the sponsor as Australian citizen or permanent resident. So as long as you're an Australian citizen or permanent resident, depending on the circumstances, um, pretty much you can apply for a partner visa. So the applicant. Sorry, there's technical error. I hope everything's good. All right. So the applicants, as long as they are not Australian citizens or permanent resident or eligible New Zealand citizen, they can apply for a partner visa. So there are three kinds of partner visa that you can apply for. First one would be the onshore partner visa. As you can see there would be 820/801. That's the onshore one, meaning the applicant needs to be here in Australia once they apply for the partner visa. And there's what we call like partner offshore visa. So it means the applicant needs to be offshore when they apply for a partner visa. And then there's what we call as well like prospective marriage visa. So the applicant needs to be offshore as well. So let's just go into details. So as I've mentioned, there is, when we call like partner onshore visa, there is like 820/801. And when we mention like partner visa offshore, it is like 309/100. It is just because these subclasses, it is interconnected. So if I say subclass, that's the 820 and then the 801, the numbers. And then for the partner offshore visa, the subclass is 309 and 100. Why do we always use like slash? So 820 slash 801, because they are connected from being temporary going to a permanent one. So let's start first with the partner onshore visa. So if the applicant is here in Australia and they want to apply for a partner visa, we need we need to do what we call like partner visa 820, which is the first stage. Now, with this partner visa, usually people who holds like a substantive visa, what if I'm saying like substantive visa, that means the person has, for example, like a visitor visa grant, currently holding like a student visa or holding employer sponsorship visa. Those are the people who can apply. But there is also a way, even though the person, for example, because in many cases, some of the in many cases, like applicants doesn't have any visa, they're unlawful here in Australia, and they found a partner. They can definitely apply for what we call partner onshore visa. So it will gonna be a different approach because they don't have a visa, right? Or they are holding a bridging visa. So that will gonna be more complicated. But the thing is, if they find a partner, then definitely we can always do a partner onshore visa. Just on the side, just on the side note, because we need to some of the applications, right? Because the visa that are given to us by Australia, I divided into two. So pretty much the other visas, I call them like just privilege, right? Because, you know, if even though if you satisfied all the requirements and the department will just gonna um, they have the decision to refuse or to grant it. It's just because sometimes they considered whether they need the person's occupation, something like that, or whether the person is a genuine visitor to visit Australia. However, partner visa is a bit different. I actually considered it as a right, like rights of an Australian citizen or permanent resident to be with their partners. So this is one of the best visas if the applicant is looking for a pathway for permanent residency. So now let's get back to the discussion about the types of partner visa. So if you apply for the partner visa onshore, even though uh, even though you're holding a visa or not, definitely you can do it. And what will gonna happen is that once you apply for this particular visa, the first stage, you're gonna definitely have a bridging visa. And that bridging visa will gonna make you eligible to apply for certain benefits here in Australia, like for example, like work rights and also a Medicare. So which is good. Even though it's still considered as the first stage temporary, all of our clients can apply already for Medicare, which is, pretty much the benefits for the benefits of an applicant who is applying for permanent residency. Because I have mentioned before that these are interconnected with each other. And let's now go with the partner offshore visa. So partner offshore visa is pretty much the same thing as I've mentioned with the partner onshore visa. The only thing that uh, the only difference is that once you apply offshore, you will not gonna have a bridging visa. So it means that you need to wait for the decision of the department and able for you to come here in Australia and apply for what we called like Medicare, something like that. So, and the other thing about the partner offshore visa, because it's more about the processing times. So That's why we would like our clients to, if they are overseas and they would like to apply for a partner visa, if they have the option to apply for a visitor visa, it's always better to come here in Australia than apply for onshore visa, so that they were going to be given like a bridging visa A and enable for them to stay here while waiting for the decision. And there is what we call prospective marriage visa. What's the what's the benefits of prospective marriage visa unlike with the partner offshore visa? So prospective marriage visa, this is an application where where the applicant needs to apply offshore. Now, if the applicant is offshore, means they need again to wait for the approval of the prospective marriage visa. However, in terms of documentation, it is partner offshore visa, the 309 and 100 is a bit complicated. The prospective marriage visa, if you are just establishing your relationship, and it's the processing times is a bit quicker as well than the partner offshore visa. As I've said, like the documentations will gonna be, uh, you know, it will not gonna be, the department will not gonna require too much documentation, unlike the partner offshore visa. So, but the thing is, we need to remember that the prospective marriage visa, the partner, all all the applicant and the sponsored needs to be like, for example, separated or divorced at least, or never been married. Because the main purpose of prospective marriage visa, once the visa is granted, then they can come here in Australia and apply and get married, within 9 to 15 months. And once they get married, then they were gonna do a what we call now partner visa onshore, which is the 820 and the 801. Now, what's the benefits of applying for a prospective marriage visa if they are offshore? In terms of the documentation, um, it just needs to, you just do need to have an intention to get married here in Australia. So those documentations needs like notice of intended marriage. And the second thing is that at least you've met each other in person. So you can't just apply for a prospective marriage visa if if both of you haven't met each other, like the sponsor and the applicant. So once you've met each other, then you can reach out to us, and then we can um, assess your case, and then yeah, apply for a prospective marriage visa. Now, there are two kinds of relationship when applying for a partner visa. The first one is what we call like married relationship, and the second one is de facto relationship. So for married relationship, if you're applying for a prospective marriage visa, we need to show to the department that you are committed, and being in a married relationship, the proof of that is the marriage certificate. And that's the only thing, marriage certificate. And for the de facto relationship, there are two ways to be considered in a de facto relationship for partner visa. The first one is that you need to register here in Australia. Some other states you can't just register. I think it's Western Australia, but I think the other states as well um, can can register their relationship. Or I, for example, if the applicant or sponsor is married to someone else, right? You can still do a partner visa, but you do need to do like, the cohabitation of what we call like at least 12 months before we apply for the the partner visa. So even though you haven't registered your relationship, as long as you've been living for together for 12 months, that should be fine. But later on, I will gonna discuss this further, because some people will just gonna say like, oh, we've been living together. However, the problem is the proof. So we can say to the department that you've been living together, but the department will gonna request documentation in relation to your cohabitation. Next one. So the only thing that when we apply for a partner visa, this is the only statement that the department that we need to prove to the department. It is um that the applicant and sponsor has a genuine and continuing relationship. So it is a pretty basic statement, but it covers four aspects of the relationship. So first thing would be the financial aspect. The second one is the nature of household. The third one is the social aspects and nature of commitment. So I'm gonna explain this further on the next slide. All right, so as I have mentioned, like these four aspects is really important because you can't just say that we have a genuine relationship and we can't prove the four aspects. So the first one would be the financial aspects, right? So the financial aspect, when you apply for a partner visa, at least you do need to open a joint bank account. And the other documentation will just gonna be an addition. It can be considered as an additional documentation or supporting documents. For example, right? If you do have joint bank accounts, that should be fine. The second one, if you don't have the joint bank account, you can either give us your bank statement that you are sharing your finances. For example, the sponsor is transferring money to the applicant, for the daily expenses. That should be fine as well. But this is a partner visa application, and it's it's quite expensive for the government fees, right? If I'm gonna be your lawyer, what I'm gonna do is just to I would like the best application to present to the department. And I think you and most of my clients have opened their joint bank account because it's an essential documentation. I think it will not gonna cost you much time in just opening the joint bank account. That's why if you're in a genuine relationship and you don't have any issues with the finances, then just open a joint bank account and the rest can just be added as, can be just considered as supporting documentation or added documentation. And the second one would be the nature of household. I know this is tough as well because other people keep on asking me what if I don't have this particular documentation, what should we do? Now I would require, when we need to prove the nature of household, I would always require a joint lease agreement, but most of my clients cannot provide joint lease agreement because sometimes they're having issues you know with their finances and everything, and then they're just living with their friends, so their names cannot be added on the lease agreement. But that should be fine because there are other ways to prove it, right? Because the most important thing, to show that you are living together, is that other documentation that we're going to state your name, state your address, and at least a date so that we can determine when you have started living together. So, and then the third one would be about the social aspects. So the main documentation that we attach, and we present to the department are the photos, because these are the most important details of the relationship. Because if you can't, pretty much we are in a digital world, and then we do have phones, right? So it's easy for us to just take photos. So it would be better if the photos that you're going to be giving to the lawyers are photos with yourselves, together with the partner and sponsor and the applicant. And if there are other peoples as well, like friends, family, much better. And the rest can be just an additional documentations, like for example, travel history, like tickets. That should be fine. But I would require more about photos, and it doesn't need to be significant. So I mean, it doesn't need to be many. It can be just at least 10 to 15 photos, because the processing times, it's a bit longer. So the relationship will gonna be progressive, right? So we can just attach later on some documentation in relation to the photos. And the last thing would be the nature of commitment. As I've mentioned before, this nature of commitment, there are two kinds of being in a relationship, right? Married couple and as a de facto couple. So main documentation that I attached to the application is that if they are a married couple, I do need the marriage certificate. And if they are in a de facto relationship, I do need their registration of relationship certificate or uh, documentation that can show that they have been living together for 12 months. Now, the difference between just sending documentation to the department and us doing the application is that it is, we present it differently with the department and we know how to present it and we know what to provide to the department. Because I've mentioned four aspects, right? What if the other one is missing? So that's why it's called four aspects because at least we need to prove, you know, one of each aspect, even though it's not strong, at least we can provide something. Now, this needs to be significant, right? When you're providing, for example, what I'm saying is that, for example, for socials, right? The photos together. You can provide to the department that you do have selfies with each other, but the question is that significant? Is that a significant picture? Because I'm just requesting 10 to 15 photos, right? If you're just having a selfie with each other and at home, that might not be considered significant, right? And if you are going to give uh, pictures to the department on the same event, but 15 photos, for example, today's the you have attended a birthday party, right? But you've submitted to the department 15 photos with just the same event. I don't think that's significant because that can be only considered as one event that just happened in one day. So these are the, this is the way how we persuade to the department that you are in a genuine relationship, not just by only stating that you have a genuine relationship, but the depending on the quality of the documentation that we were going to provide to them. Okay, so next one would be the common mistakes that the applicant and his sponsor do in their application. So inconsistent evidence. Usually with this consistent evidence is that because there were going to be documentation that we were going to require from the sponsor and then the applicant. For example, relationship statements, right? For the relationship statement, you can mention, oh, for example, we've been in a committed relationship starting on 13th of October 2025. However, you don't have any documentation, or if ever that you do have documentation, for example, you have this joint lease agreement, right? Dated maybe 13th of November. So there's a gap, when you mentioned like 13th of October, that's the time that you've been committed, but you only provide to the department a joint lease agreement on the 13th of November, which makes it, you know, which makes it inconsistent with the actual evidence that you do have. So the department will gonna come back and then we're gonna request further information, documentation, or explanation from both of you just to explain what you have mentioned to the department and what you have provided. So this is really important. This is because we've been doing this day and night, and then we know what to place, what particular date to place, enable for us to make it consistent with the evidences that we do have. The second one, insufficient proof of cohabitation. As I've mentioned previously, that, for example, right, you don't have lease agreement and you only have other documentations that you have been living together, but sometimes it's not sufficient, right? Because the thing is, the department needs to have documentation that states your name, the actual address, and at least the date. Those three things are really important to show that you, as the applicant, has been living there in that specified address. And the third one, the date when you actually been starting living together. It doesn't need, sometimes, because as lawyers, we just need to explain to the department, right? The reason why, for example, you do have a documentation that you've been together, for example, like a mail, right? You've received the mail in October, but 2025, but you've been living together, let's just say September. That should be fine because we can reason out to the department that you've been living together in September. However, you have just received a documentation dated 13th of us, dated October 2025. That should be fine because, when you started living together, the documentation should be so it means that we can always reason out to the department that you've been living together prior to that date that is on that particular evidence. Now, missing translations or certified copies. When we are attaching documentations to the department, and if the documentations are here in Australia, we don't need it to be certified. In some cases, maybe yes, but if it's in here in Australia, we don't need to. And in terms of translations, because this is not the same application as like, um, employer sponsorship visa. This is more about the partner visa, right? So it means there's no like English test, there's no employment reference coming from your employer. So meaning it will gonna be more about the relationship. So I think the documentations that we just need to um, needs to be translated are your identity documentation. And if you are married, then overseas, then that particular documentation needs to be translated. Other than that, um, those documentation, because we will need to assess it, right? So we will just gonna inform you whether this documentation needs to be translated. For example, overseas police check, if it's not in English, it needs to be translated, and it needs to be translated by certified translators. It cannot just be, oh, it's someone who translated this, or sometimes I've experienced that, the police check was just translated by Google Translate. Um, we don't accept that. It needs to be translated by a certified translators. Now, the processing times. If you go to the department's website, right, you're gonna see that the processing times for the partner visa, it might take like a year or 2 years, right? 90%, 90% of the application are being processed like in 2 years or maybe more. But it depends on the application, right? If this application is less difficult or less complicated, the application might be granted within a year. I do have clients who I do have clients that their application has been approved in 4 months, 6 months, 8 months, 9 months, or 10 months. And I do have some clients as well whose applications have been approved in like 15 months because it depends on the circumstances. Later on this slide, I think um it will gonna be mentioned as well regarding the complications of the of the application. Because remember that even though the partner visa is only for the applicant who are not Australian citizen or permanent resident, since it needs two people who is a sponsor and an applicant, so the department also considers, the character of the sponsor, like an Australian citizen or permanent resident. If the sponsor has a um was this has a criminal records, for example, that will gonna delay the application. But the thing is, um, since you are engaging with a lawyer, right? it depends on the degree of the conviction or the criminal matters that they have underwent. So, but pretty much the thing is there will always gonna be a way. So if you're applying for a partner visa and then your sponsor has character issue, then you just need to speak with a lawyer because they will most of the time they will gonna always find a way, but you do need to consider that this will gonna delay the application because the department will gonna scrutinize the application more. Now, in relation to the bridging visa rights, right? So as I've mentioned earlier, like if a person has a substantive visa, meaning they are not on a bridging visa and they don't have, they're not on a bridging visa and they're not unlawful, that's the substantive visa. If, for example, if they're holding like tourist visa, student visa, employer sponsorship visa, once you apply for a partner visa, then even though you're on a visitor visa, the bridging visa that will gonna be given to you will gonna have like full-time work rights. However, you do need to consider as well that the bridging visa that will gonna be given to you, even though it has work rights, it needs to be activated first. For example, you you do have a valid visitor visa, right? Multiple entries, and each day is 3 months. Then 3 months will gonna be expiring in March, right? And then you applied this year for a partner visa, meaning the bridging the bridging visa for the partner visa will gonna be activated in March. For example, 5th of March, right? That's the expiry of your visitor visa. The the partner visa bridging visa will gonna be activated on the 6th of March 2026. So you do need to um, always take note of the bridging visa conditions as well, because some other bridging visa, for example, if you don't have the substantive visa, right? If you are on a bridging visa or the applicant is unlawful, they will gonna be given a different bridging visa, and most of the time they will not be gonna be given like work rights. But there's a way, that we can ask the department to overturn the conditions, and then we can ask for a work rights. So yeah. Okay, this now we go to the complicated situations. Like what will gonna happen there if the relationship breaks down, right? The relationship broken down while the partner visa application is still processing. So there will gonna be ways for the applicant to achieve their permanent residency in limited circumstances. For example, the first one would be domestic violence, the death of the sponsor, or they do have a child or children with each other. So this will gonna be different because and it will gonna be difficult because this is not a usual application. So the department will gonna come back to you, and then we're gonna request for further information or something about invitation to comment. And I would suggest to seek a lawyer's advice in relation to this, because the thing is you don't know how to reach out with a department, right? And what's the best way to reach out to them, and what are the things that needs to be included or what needs to be submitted to the department, enable for you to show your side and make a legitimate claim about this. So but if the relationship has broken down without domestic violence, the death of a sponsor, and you don't have any child, it will gonna be difficult to achieve permanent residency. So yeah, and then the second one would be the previous sponsorship or partner visa. So as I've mentioned, there are two people. We do need two people in order for us to apply for a partner visa. The first one is the sponsor, and the second one is the applicant. Now, the sponsor, if if the sponsor has already sponsored twice, well, usually the maximum is twice, two. But if the sponsor already sponsored like two times, it will gonna be more difficult to apply for a third one. But I'm not just saying that it is impossible, but there's always a way for us to apply for the third one. It just needs a compelling and compassionate reason to be submitted to the department. Why does the sponsor need to sponsor a third applicant? And yeah, the second one as well. If the sponsor, for example, they got their permanent residency through partner visa as well, so they can only sponsor someone after 5 years. So, but there's a way as well, because if you met someone and then it's not, it's not yet 5 years. Uh, we've we've done some cases as well, and it has been fortunate for the applicant that the department sided us and having a positive decision. So I'm not because the thing with the department is that if you have a valid case and you do have a compelling, compassionate reason, the department has always a um, give chances to the applicant to gain their partner visa to be valid, and most of the time, granted in the future. And the third one would be divorce or separation. So as I've mentioned previously, like when you are applying for a partner visa, if you are married to someone else, then if the sponsor or the applicant is married to someone else, then you can't just apply for a partner visa. It's either you divorce first here in Australia, then apply once you got the divorce certificate, then you can apply for a partner visa. However, if if the divorce will gonna be difficult, still there's still a way, um which is what we call like living together for 12 months. Right. And the other thing about I already mentioned this about the character or health concerns, right? So if the applicant or the sponsor has this character issue, it will gonna definitely make the application difficult to prove to the department that, especially for the applicant, because the thing is, if the applicant has this character concerns, right, issue, and then, as I've said, this application is leading towards permanent residency. If the applicant has substantial offense or character concerns, the application might be refused in the future. It's just because of the character, because this will gonna lead to the applicant's permanent residency and later on being um, eligible to apply for Australian citizenship. And same as health issues as well. So we have we do have clients whom applied for a partner visa and who are suffering from HIV, cancer as well, and other major health issues. But the good thing about this is that even though the department comes back to us, as long as we do have this documentation and substantial reasoning that we can show to the department as compelling and compassionate reasons. But as I've said, this is not only the part of lawyers. This should be also the part of the applicant and the sponsor, because we do need documentation. Because whatever that we can reason out to the department, they will gonna always come back to us and request for further documentation or proof um, to back up our reasoning. But as I've said, like we've done many cases about this, and then most of those cases have been successful because we've showed to the department that it's doable, and it doesn't. it will not gonna put the applicant, and other people as well in trouble. So those are the approaches that we do if there are, character or health concerns that the applicant or the sponsor are suffering. And the last one would be in relation to the visa status. Now, there are some people who comes here in Australia on a visitor visa. If the condition is like, for example, multiple entries, that should be fine. But there are some conditions on the visitor visa that says like no further stay. It means that the applicant is being limited to apply for most of the visas. And if you do have that particular condition on your visitor visa, well, you can't just, we would advise not just to apply for a partner visa straight away. There is a process. So the first thing is to waive that no further stay condition. In order to waive that no further stay condition, as I've said again, we do need documentations um, like from medical experts, for example, then submissions to the department why the applicant's condition needs to be removed, the no further stay, and it will just gonna be back and forth with the department, so it will gonna be difficult. But the thing is, it's not a visa application, right? It's a waiver. So sometimes if you don't get it on the first one, then you just need to make the application stronger again on the second one, means needs further documentation. All right, so that ends the my presentation. So if there are some questions, feel free to ask me or type it in your chat box. So I do have a question. Okay. So someone raised a question. How long do you need to have been living together or an approved occupant on the same lease before applying for a partner visa? So it just depends. So if, as I've said, like if, for example, if both of you are are married to someone else, then you do need to, because you can't just register your relationship or you can't get married, right? Because one of it's either the applicant or the sponsor is married to someone else. So it means that you do need to prove at least 12 months cohabitation, 12 months of living together before you can apply for a partner visa. It depends on the application. I do have some clients who would like to apply for a partner visa even though they haven't satisfied the 12 months cohabitation, even though they're married to someone else, because they can't register the relationship and they can't get married, right? But they would like to lodge the application for a partner visa. Well, you can still do it, but I'm not saying that it is always the case. It depends on the case, because I need to bring up, the compelling and compassionate reason to persuade to the department that the applicant and the sponsor are in a genuine relationship. However, they just can't satisfy the 12 months cohabitation. And Second one would be my partner and I are only together for 5 months. We got certificate proof of relationship last week and want to apply for partner visa ASAP. Is that possible? Yes, that's possible. Because as I've said, like if you have registered your relationship, then you can apply for a partner visa. But you do need to take in you do need to take in consideration that there are four aspects of um, relationship that you do need to prove to the department. Because even though you have just registered your relationship and you haven't satisfied these three aspects as well, the application will not gonna be that strong when you apply for a partner visa. And the thing is, we need also to consider what visa are you currently holding? Because if you are not holding a substantive visa, you might have an issue, when you apply for a partner visa. And take note that I'm not scaring you guys, but you just need to take note that sometimes it's not about just lodging the bridging visa, lodging the partner visa and wait for the decision. Sometimes it's not like that. When you lodge the partner visa, it might come invalid. So the I've seen hundreds of cases like this, like uh, with especially with our new clients coming to us because they said that the application has been invalid. It's just because when you lodge the application, it's not even though you have documentation that you do need to prove to the department, there are still some wordings that needs to be specific when you are lodging the application that needs to be mentioned. So it's not just like apply the application. That's why you also need to consider like anyone can apply for a visa, right? Here in Australia. You need to consider that, yes. However, are they actually submitting a strong application, a visa application? And are they presenting was it presented good, and were the documentations presented substantial or significant? And how have you presented it to the department makes a lot of difference. I think yeah, I think there are no more questions. I really appreciate your attendance here, everyone, attending this webinar. I do really enjoy it. Hope you got um, uh, good ideas about, partner visa. So yeah, thank you very much. And if you do need further information about the partner visa, it's tailored particularly on your case, you can contact us here at No Borders. So what makes it easier is that you can just type in the No Borders in Google, then you can just ring us, and then one of our agents or lawyer will gonna be in contact with you and can have a free consultation.